Good afternoon, everyone. My name is Preet Bharara, and I'm the United States Attorney for the Southern District of New York. Today, we unseal a criminal complaint charging the longtime leader of the New York State Assembly, Sheldon Silver, with public corruption. Speaker Silver surrendered to the FBI in Manhattan earlier this morning, and we expect him to be presented in federal court this afternoon. Over his decades in office, Speaker Silver has amassed titanic political power. But as alleged, during that same time, Silver also amassed a tremendous personal fortune through the abuse of that political power. The complaint charges Speaker Silver in 5 counts with corruptly seeking legal business from a handful of people and entities with significant business or interests before the state, and then corruptly profiting from the legal fees that were paid. All told, we allege that Silver corruptly collected some $4 million in bribes and kickbacks disguised as referral fees. Those disguised bribes and kickbacks account for approximately 2/3 of all of Silver's outside income since 2002. So today, in order to prevent Silver from accessing his alleged ill-gotten gains, we also announce that the court has issued warrants allowing us to seize approximately $3.8 million in alleged fraud proceeds that Silver had dispersed among 8 different bank accounts at 6 different banks. For many years, New Yorkers have asked the question, how could Speaker Silver, one of the most powerful men in all of New York, earn millions of dollars in outside income without deeply compromising his ability to honestly serve his constituents? Today, we provide the answer. He didn't. As alleged, Silver corruptly used his law license and took advantage of lax outside income rules as a cover to secretly pocket millions of dollars through his official position. For many years, New Yorkers have also asked the question, what exactly does Speaker Silver do to earn his substantial outside income? Well, the head-scratching can come to an end on that score, too, because we answer that question today as well. He does nothing. As alleged, Speaker Silver never did any actual legal work. He simply sat back and collected millions of dollars by cashing in on his public office and his political influence. Now, we are by no means the only ones to have sought answers to these important questions. The Moreland Commission, as you may recall, tried to get to the bottom of some of these questions also, but a deal was cut that cut off the commission's work, to the great relief of Sheldon Silver, who furiously fought its subpoenas and urged the commission's early shutdown. Moreland was made to close its doors after only 9 months, its work barely begun, and while litigation over those subpoenas about Sheldon Silver's outside income was still pending before a state judge. So my office, as you know, took possession of all of the Moreland files and merged the commission's incomplete investigations with our own ongoing ones. And it quickly became clear that the mystery of Silver's outside income needed to become an even greater priority. As today's charges make clear, the show me the money culture of Albany has been perpetuated and promoted at the very top of the political food chain. And as the charges also show, the greedy art of secret self-reward was practiced with particular cleverness and cynicism by the Speaker himself. Now let me get into some of the details of the charges we announced today. The central allegation in this case is that Speaker Silver successfully sought ways to monetize his public office, and that he did so in violation of federal law. As alleged, Silver quietly and cleverly figured out how to monetize his position as Speaker of the Assembly in 2 principal ways. In both cases, as alleged, Silver cynically abused his law degree and New York's lax disclosure rules to disguise kickbacks as legal referrals. Let me talk about the first. As alleged in the complaint, in 2002, Sheldon Silver established an arrangement with the law firm of Weitz and Luxenberg, which was mostly in the business of asbestos litigation. That arrangement called for him to be paid $120,000 a year, even though Weitz and Luxenberg admits hiring him based on his official position rather than any work he was expected to perform for clients of the firm. But that wasn't enough for the Speaker, because Sheldon Silver understood that he could substantially supplement his income if he could cause asbestos referrals to be made to the firm. Now, the problem for Sheldon Silver was that he was neither a doctor nor an asbestos lawyer. So Silver did not have any relevant legal or medical expertise. But what he did have was extraordinary power over state money that he had the ability to dole out quietly, even secretly. So Silver, as we allege in the early 2000s, forms a relationship with a doctor who is an expert in asbestos-related disease and who can get Silver what he wants because he treats many patients who might have asbestos-related claims. Silver wants referrals so that he can substantially increase his income even without doing a lick of work. So as alleged, he asks the doctor to refer people who have asbestos diseases to Silver at the firm of Weitz and Luxenberg, with which Silver had conveniently formed an affiliation. But the doctor wants something too. What the doctor wants is money to fund his research at a hospital in New York. And it turns out that the doctor is in luck because, as I mentioned, Sheldon Silver has access to enormous amounts of public money, including an $8.5 million fund from which he can, in his sole discretion, without disclosure and without transparency, cause funds to be distributed to the doctor's research center. And that's exactly how it worked. Sheldon Silver tells the doctor to send referrals to Weitz and Luxenberg, from which Sheldon Silver profited through referral fees, and in return, Silver, on multiple occasions, takes official action for the benefit of the doctor and the doctor's interests. As you'll see if you look at the complaint, first, Silver causes a $250,000 state grant to go to the doctor's research center. Then he causes a second $250,000 grant to go to the center. Then, when the ability to secretly pay money from the state evaporated because of a sudden change in the law, Silver finds other ways to use his official position to perform favors for the doctor. Silver helps the doctor's family member get a job. Silver directs $25,000 in state funds to a not-for-profit where another family member of the doctor served on the board. And Silver even gets the legislature to issue an official resolution honoring the doctor. And so at the end of the day, all told, we allege that Sheldon Silver effectively converted $500,000 in public money into over $3 million in personal riches, which is a nice profit on being a public official. By the way, as described, Silver did all of this without ever disclosing to Weitz and Luxenberg or to the public that he had directed $500,000 to the doctor's research center. And as with so many things depicted in the complaint, Silver did things quietly and under the radar. Now let me talk about the second corrupt way that Sheldon Silver illegally monetized his public position. That was based on his power over the real estate industry. Once again, Silver uses his affiliation with a law firm, in this case, a tiny real estate law firm, whose lead partner is his former assembly counsel. That firm has only 2 lawyers and a very narrow specialty: tax reductions. In other words, it helps developers make applications to the city of New York to lower their property taxes. Unlike with the asbestos law firm, Silver keeps his financial arrangement with the real estate law firm completely secret. He doesn't even comply with state disclosure laws requiring him to identify with specificity all sources of income. But as is the case with the asbestos referrals, Sheldon Silver does not have any relevant legal qualification, none. He has no real estate tax experience whatsoever. But what he does have, again, is tremendous authority and power he was privileged to have by virtue of his public position, over rent control laws and tax abatement laws that are critically important, even existentially important, to the business models of some of the largest real estate developers in the state. And he abuses that power just as he does in the healthcare context that I just described. Let me tell you that story. As alleged, some years ago, Sheldon Silver approaches two prominent developers of substantial properties in Manhattan, one personally and the other through a lobbyist, which lobbyist, by the way, was hired by the developer to lobby Silver. And he asks those developers to switch law firms and hire a different law firm, the real estate law firm that Silver had a secret financial arrangement with. And the developers, they oblige. And that is not surprising, because Silver is a powerful political leader in the state who holds sway over so many laws and policies near and dear to the developers' bottom lines. So the developers hire the firm and paid a cut of whatever millions of dollars the real estate law firm saves them in property taxes, and Silver gets a cut of that cut, and he gets it secretly. In return, as alleged, Silver does not disappoint those developers when it comes to official state business that they care about. During the time that Silver is pocketing money from developers, he continues to hear out lobbyists who are working in favor of one of these very developers. And as set forth in the complaint, certain of that developer's recommendations ultimately are adopted by the legislature. And, as set forth in the complaint, when rules come up for renewal that are absolutely critical to the financial success of those developers, the developers are pleased with how Sheldon Silver comes out on their issues. In fact, as the complaint describes, on one occasion, a real estate industry group stated that landlords were surprised by how favorable Silver was to their position, and that Silver could have done more for tenants. And so, as alleged, in exchange for exercising power over issues that were of concern to the developers, Sheldon Silver converted his public authority over property laws into $700,000 in personal profit, and none of that has ever been publicly disclosed. If you look at the charts to my right, they depict graphically how simple a scheme it was and how parallel they are. As I described, with respect to the asbestos litigation kickbacks, you have Sheldon Silver, as described in the complaint, has a relationship with a doctor, does official favors for that doctor to the tune of $500,000 in state grants. Similarly, in the case of the real estate kickbacks, Sheldon Silver develops a relationship with real estate developers, some of whom he knows because they lobby him, and is in a position to exercise power over real estate and tax abatement laws, and then manages to line his pockets in both instances, essentially through law firms that served as pass-throughs so that he could hide what were essentially kickbacks and bribes as legal referrals. In that case, over $3 million, and in this case, over $700,000. Now, as you can see, a theme running through all of these charges is secrecy, the hallmark of many a criminal scheme, and Silver's was no different. Indeed, the complaint sets forth the many ways that Speaker Silver lied and misled the public about his outside income to hide his scheme. You can look at the complaint to see the others, but here's one that is particularly egregious. In response to recent questions about Silver's outside income, the Speaker had his spokesperson flatly state that, quote, none of Silver's clients have any business before the state, close quote. But as we allege, it would be hard to find a more blatant falsehood, given that Sheldon Silver was retained by one of the largest developers in the entire state, with huge business before the state legislature that Speaker Silver himself purports to help to lead. In fact, I urge you to read the portion of the complaint that lays this out. You'll find it at paragraph 32. In other words, what we allege is that Sheldon Silver, Speaker of the New York State Assembly, was in fact on retainer to a mammoth real estate developer at the very same time that the chamber he dominates was considering and passing legislation vitally affecting the bottom line of that developer, at the very same time that he was hearing out lobbyists paid by that developer, and at the very same time that he was deliberately keeping secret from the public any information about this lucrative side deal in violation of the law. And by the way, many of the laws described in the complaint that are important to the real estate industry are up for renewal in the legislative session that has just begun. Politicians are supposed to be on the people's payroll, not on secret retainer to wealthy special interests they do favors for. These charges, in our view, go to the very core of what ails Albany: lack of transparency, lack of accountability, and lack of principle, joined with an overabundance of greed, cronyism, and self-dealing. But we will keep at it because the men and women of the FBI and of my office still subscribe to the quaint view that no one is above the law, no matter who you are, who you know, or how much money you have. And so our unfinished fight against public corruption continues. You should stay tuned. I want to thank the many people who brought us to this point before I turn the podium over to the FBI. This was a lot of work on the part of a lot of people, not only because we had our own independent investigation, but then took over the burden of continuing an investigation that had already begun with respect to the Moreland Commission. And so this is an extraordinary example of extraordinary work by, I think, extraordinary people. First, I'm joined here by the Federal Bureau of Investigation, represented today by Rich Frankel, the Special Agent in charge of the Criminal Division, George Kazami, Assistant Special Agent in charge, and James Barnacle, Supervisory Special Agent. I also want to thank those at the FBI who have helped make today's case possible, including FBI Special Agents Richard Wilfling, Paul Takla, and Elizabeth Bracco. I want to recognize the dedicated career prosecutors and criminal investigators in my office who worked so hard to make this case possible. I don't think there's a group of people anywhere who has done more to make sure that our leaders behave with integrity, and if they don't, they're accountable for it, than the group of people who are the team in my office. And they are, in this case, Assistant U.S. Attorneys Howard Master, Carrie Cohen, Andrew Goldstein, and Jamie McDonald, supervised by Arlo Devlin Brown, the chief of my office's Public Corruption Unit, and criminal investigators Bob Ryan and John Barry, who were absolutely essential in getting this case done. And I also want to thank the leadership of the office that spent extra time making sure that this case got done. Deputy U.S. Attorney Rich Zabel, Criminal Division Chief June Kim, and Chief Counsel Dan Stein. And I think people in New York and elsewhere should be really proud of the dedicated career men and women who have done so much work on this case and cases like it. Now let me call Rich Frankel, Special Agent in charge of the FBI's Criminal Division, to the podium.
Good afternoon. For nearly 2 decades, Sheldon Silver has served as Speaker of the New York State Assembly, a position that has afforded him significant power over the workings of state government. As alleged, Silver took advantage of this political pulpit to benefit from unlawful profits. When all was said and done, Silver amassed nearly $4 million in illegitimate proceeds. He also arranged for approximately $500,000 in state funds to be used for projects that benefited his personal plans. The nature of his earnings went virtually undetected until today. Silver's wallet was enriched through his association with a physician to whom he issued state grants and other favors made possible through his official position. In exchange for favors, the physician referred patients with asbestos-related diseases to Silver at White's and Luxembourg, a law firm where he was affiliated as counsel. In the end, Silver received over $3 million in proceeds from the patients referred to him, and more than $500,000 in state money was allocated for projects that directly benefited the doctor and his family. But the special treatment did not stop there. Silver also received more than $700,000 in kickbacks after leading 2 real estate developers with business before the state to a law firm run by a co-conspirator with whom he had entered into a corrupt relationship. He later supported a proposal made by one of the developers, which was, in substantial part, enacted into legislation in 2011. We hold our elected representatives to the highest standards and expect them to act in the best interests of their constituents. In good faith, we trust they will do so while defending the fundamental tenets of the legal system. But as we are reminded today, those who make the laws don't have the right to break the laws. Thanks, as always, to our partners in this and so many investigations. U.S. Attorney Preet Bharara, Assistant U.S. Attorney and Chief of the Public Corruption Unit, Arlo Devlin Brown, Assistant U.S. Attorneys Carrie Cohen, Howard Master, Andrew Goldstein, and James McDonald. I'd also like to thank and congratulate the investigative team that worked together to address corruption in New York. I extend my sincere congratulations to Robert Ryan and John Barry, criminal investigators from the Southern District of New York, as well as FBI Special Agents Rich Whiffling, Paul Tackler, and Elizabeth Bracco, as well as Supervisory Special Agent James Barnacle and Assistant Special Agent in Charge George Kazami for their work on this important investigation. Thank you.
Thanks, Rich. I can't imagine you have any questions, but if you do, I'm happy to take them. Yeah.
First of all, you've dealt with a lot of public corruption cases over the last few years, but when you look at this complaint, the allegations are breathtaking compared to what we've seen in the past. I wanted to see what your reaction was, though, in comparison to the other charges, the other kinds of complaints we've seen in the past. I don't know if you were sad, angry, oh, just more of the same out of Albany. What did you think?
First of all, I don't think any particular emotion I have matters and is not relevant, but look, I think the complaint speaks for itself. When you have an allegation not against, anytime you have an allegation, especially when it's proven, against a public official, that is dispiriting. And when you have an allegation against someone who's a public official, not just in a rank and file capacity, but a leader of an entire body who is known to be, in the parlance of Albany, one of the three men in the room, that is especially dispiriting. So the nature of the person who is being charged obviously matters and is different from the kinds of cases we have brought before. Separate and apart from that, the nature of the allegations, I don't know that it's that radically different from some of the other cases that we brought, but it is troublesome and worrisome when the charges, as we describe, go to what I've described as the core of the problem there. It's about money, it's about lobbying, it's about powerful interests, it's about lack of transparency, it's about all of those things that that you see in case after case after case, all of which seem to be tied together in the allegations in this particular case. Yeah.
But there are still several Democrats in the Assembly that are standing by him. What do you make of that?
You should ask them. You know, we have brought charges. These are charges, and I should make clear, as we always do in every case that we bring, we have to prove the charges. And Sheldon Silver, just like everyone else who gets charged by this office, by any state prosecutor, is innocent and is presumed innocent unless and until proven guilty. But as to, you know, what the threshold is for other politicians to stand by a particular politician who holds great sway over them, you would have to ask them that question.
You said stay tuned for more possible. Are you talking about the Warren Commission stuff, or is also from other sort of investigations?
As I said, you know, in this case, as we outlined in the complaint, we had been looking at Speaker Silver's outside income for some period of time and then merged our investigation with new material that we got from the Moreland Commission. We have a number of public corruption investigations going on. We had them before the Moreland Commission existed, and we have them after the Moreland Commission was shut down. So I'm not going to say which are merger cases and which aren't, and I'm not going to tell you which people we're looking at. So stay tuned was intentionally very vague. Yeah, yeah.
Mr. Barr, I'm wondering if you think the Governor Cuomo's decision to shut down the Moreland Commission while Speaker Silver was filing charges to prevent him from making disclosures makes the governor complicit in helping Speaker Silver to cover up his financial situation.
Yeah, I'm not going to comment on that. I think I've made my view about the shutting down of the Moreland Commission clear. That's all I'll say. Yeah.
Is Mr. Silver accused of extorting the governor when it comes to quashing the Moreland Commission? And if not, whom is he accused of extorting?
I think it's laid out in the complaint in counts 4 and 5, both extortion under color of official right and conspiracy to commit that extortion with respect to the developers from whom he tried to get money passed through a law firm, not the governor. No. Yeah.
How commonplace do you think this practice is?
Well, when you say this practice, if you mean by public corruption, it's really commonplace based on the cases that we have brought.
The nature of what he's doing specifically, that there are referrals as opposed to kickbacks and stuff.
Yeah, well, we brought a case some years ago before I was the U.S. Attorney. You know, the public corruption work of this office preceded me and will you know, come after me also, where someone from the state legislature was not a lawyer and was taking money as a consultant. So it is not the first time that someone in public office has tried to figure out a way to monetize his office. I think we were up here 2 years ago quoting from people who were taped on body wires talking about how important it was for them to figure out a way as public officials to capitalize on that and make money. So the theme of people trying to make money from their public position is not a new one.
How long did this investigation go on for? How long were you looking at outside income?
I think we say in the complaint that we began looking at some of these issues in June of 2013.
Sir, if Mr. Silver's charged, why aren't the real estate developers charged? Why isn't the doctor charged? And how do you show quid pro quo? It's a good thing, it's going to refer patients who need help. It's a good thing, you're going to make money from the state to help a hospital out. Where's the quid pro quo? How do you do that?
As to the first, we make decisions about charging based on all the facts that we have. I should have said, as I always say, the investigation is open and ongoing and is not done. With respect to the doctor, based on a lot of circumstances, as I think is outlined in the complaint, he received a non-prosecution agreement for his decision to cooperate with us and provide testimony. As to how you decide, you figure out whether something is a quid pro quo or not, as I think case law says and common sense tells you, it is very rare that you have a written agreement in which someone says, I'll pay you this bribe, and then you do this favor for me. There are a lot of people who are not so bright in office, but there are a few who are that silly and stupid. So you prove by circumstances, which I think are outlined fairly compellingly in the complaint. You had a person, and I think there are documents that describe what the doctor's understanding was, and I think those documents make clear that the doctor's understanding was, if I make sure that you have this stream of referrals that go to this law firm, then I can get something for that. That, I think, we believe a jury will find to be a quid pro quo. And with respect to the real estate side, remember we're talking about two ways in which he had outside income that we think was unlawful. With respect to the real estate side of the case, that was a situation in which he made a direct request to the developers, in one case through the lobbyist who had been hired by the developers to go get him to do things. And by definition, they had business before the state, because presumably that's why you hire a lobbyist, to lobby on issues relating to the state, including lobbying specifically Sheldon Silver. And as outlined in the complaint, Speaker Silver says to that lobbyist who sent to help orient him in favor of the developers, you tell them to switch law firms and send their tax abatement work to this other firm. When Sheldon Silver knew, that firm was run by a former colleague of his, and he had a secret financial arrangement with them whereby he would get money. A jury will decide whether or not that's a quid pro quo, but we think it is.
At another press conference like this announcing the corruption case, you mentioned you called for the legislative bodies to step up to the plate and make sure that that more cases like this don't keep having to come down the pipeline. Since that press conference, has any even state legislative action taken, and if not, what do you call it?
I don't remember which press conference you're talking about. There was this intervening commission that started and stopped. I'm not a legislative expert. I think that I have said many, many times, both at this podium and in other places, that solving the public corruption problem in Albany and in the city and in other places is more than a prosecutor's problem. The legislators themselves have to step up, the public has to step up, the press has to step up, and there's no one panacea or solution. I'll give you an example of something, by the way. I don't know if you follow this from the complaint. With respect to the asbestos side of the case, we allege that on two separate occasions, $250,000 was given out of what was essentially an $8.5 million discretionary fund from which the Speaker himself could give money at his will and his whim. And the ability to do that in a secret way, in a non-transparent way, ended in, I think, 2007, because remarkably, there was a little bit of reform that occurred then, and as soon as the law changed with respect to the Speaker's ability to, in a non-transparent way, dole out money to anybody he wants, including to the doctor with whom we say he had a corrupt relationship, that money stopped. And as we also say in the complaint, there was nothing that prevented a very, very powerful Speaker who had other avenues to provide money to somebody with whom he had a relationship, if he cared and believed in the work that was being done, mesothelioma research, and helping people who maybe became diseased after working on 9/11. There's nothing that prevented that Speaker, with all that power and all those purse strings, from continuing to give money to that fellow, and he stopped, we allege, because he could no longer keep it secret because it was a corrupt relationship. So that's an example just from the complaint of something that happened in 2007 when more disclosure is required and more disclosure is necessary. It makes it a little bit harder for bad people to do bad things. I think it was the Budget Reform Act. Yeah.
The theft of honest service charges against Speaker Silver, are you more confident that the government will be able to succeed in bringing charges these charges, given the past cases have not been as successful?
You're asking us if we hope we'll prevail? The answer is yes.
But with regard to specifically to the theft of honest services, how do you feel like this
Yeah, we only well, because we allege that these were basically kickbacks and bribes, and there was a Supreme Court decision a few years ago that eliminated some ability to charge honest services fraud, which I think is what you're referring to, but it left clearly open the prosecutor's ability to charge quid pro quos, which is why Mr. Dean asked that excellent question, and we believe we make that out.
Excuse me, was the immunity order needed to force Attorney One's grand jury testimony and other statements to the government?
I'm sorry?
Was the immunity order needed to force the Attorney Number One's grand jury testimony and other statements to the government?
We grant immunity requests very infrequently, very, very rarely, and we take those requests very seriously. And I'm not going to get into the reasoning of in this particular case, but from time to time you do that in the criminal justice system, and the criminal justice system allows for it, and we felt it was appropriate in this case.
How much of your case comes from the files of the Moreland Commission? Could you have brought these charges just on what the Moreland Commission got?
Now, I'm not going to say how much was them, how much was us. What we say in the complaint very clearly is we were looking at this, and we were delving into some of the details, and the Moreland Commission was asking some of the same excellent questions, and we took over, and the combination, it's a hypothetical, I don't know the answer to that. That's all I'll say.
What kind of sentencing are we looking at? How much time could the Speaker potentially spend in prison?
There are 5 counts. The maximums on each of the counts is 20 years. Again, that's just a guideline. That doesn't mean that's what the actual exposure is, because the sentence is up to the judge in consideration of the sentencing guidelines, which are not, mandatory, but those are the maximums, yeah.
Could you speak to the timing of the arrest? Yesterday, the Speaker was on stage with Governor Cuomo. He was reelected, like you said, the Democrat. It seems like you're trying to send a message.
No, we bring cases when we have the evidence and we have crossed all the T's and dotted all the I's. If we've been able to do the arrest and got to the point where we could have done it 2 months ago, we would have done it then. If we didn't feel like we were ready to do it today, we wouldn't have done it today. A lot of people spend a lot of time speculating about timing of things. We do the case when it's ripe.
Possible prosecution inside of the real estate situation that you said you non-prosecution agreement on the photographer side.
Yeah, I'm not going to comment on who else is potentially subject to criminal liability beyond what's already in the complaint.
You paid taxes on all this one?
I'm not going to comment on what taxes he did or did not pay. I don't think Arlo wants to come up to the. I'll tell you what it's like for him. You should absolutely.
Well, all I'm going to say is that we work extensively on every case we work is with the U.S. Attorney's Office. We have a great relationship with them. We work with their investigators daily, hourly. This was truly a joint effort between the FBI and the Southern District of New York, and we are lucky to work with these prosecutors. We truly think we have the best prosecutors in the United States. I don't want to go into roadblocks, other than to say, whatever roadblocks we did have, we'll have discussions. We'll continue to work through any of those roadblocks. There are always issues and cases, and you always work through those issues. And I don't want to go into specifics at this time, because again, as the U.S. Attorney has said, this is an ongoing investigation, and we will continue on with it.
What's the difference between a sealed complaint and a sealed indictment?
One's a complaint and one's an indictment. I'm sorry. A complaint is approved by a judge upon the affidavit of a law enforcement officer based on probable cause. An indictment is a document that is approved by a grand jury, a federal grand jury. And so when you proceed by complaint, that doesn't negate the necessity of ultimately having to obtain an indictment if you go forward. So you can expect an indictment in the future.
As you said, you've been investigating since June 2013. From then till now, did you see any modification or increased attempt to hide this on behalf of the speaker? And secondly, if the speaker's lawyer argues that client referral is working, how do you counter this?
Well, for the second question, show up in court and you'll find out. With respect to the first, I don't know if there's any example in the complaint that goes to your question of whether or not there were additional attempts to hide. I think what's significant is not whether or not there were greater attempts to hide conduct and transactions and bribes and kickbacks over the last period of months, but that was a hallmark of the entire scheme that goes back many, many years. There were very, very few people who knew about any aspect of this. With respect to the real estate kickback scheme, there were virtually no human beings who knew all the details of it. And that, going back to the question someone asked earlier about what roadblocks you have, that's a little bit of an investigative roadblock. When someone is smart and clever about how they are hiding streams of payment and the disclosure laws don't make it any easier for you, that can be a roadblock. But luckily we were able to clear away the roadblock and proceed to the point we are. Last question. Yes, we have. It's frozen, and he can't access it without leave of the court. And at such time as there is a conviction, then we take the proceeds, basically. Thanks, everybody.